A sale is a contract in which ownership of goods transfers immediately from the seller to the buyer for a price. Ownership entails a collection of rights including the right to hold title, possess, use, enjoy, profit from, waste, and even destroy the subject property. Goods are tangible, movable items of personal property. They are tangible in that they are perceptible to touch. Examples of goods are airplanes, books, clothing, and dogs. Price is the consideration for a sale or contract to sell goods. Payment occurs when the buyer transfers the agreed-upon consideration and the seller accepts it. Delivery is the act by which the subject matter of the contract is placed within the possession or control of the buyer. Receipt of goods means that the buyer takes physical possession or control of the goods. Receipt usually involves actual delivery. However, delivery may be constructive. This means that there is no actual transfer of possession of the goods. Confirming goods are goods that specifically fulfill the seller's obligations under the contract. Non-confirming goods are goods that do not meet the buyer's specifications or are defective in some way. Specialized rules may be applied to individuals who are merchants. A merchant is someone who deals regularly in the type of goods being exchanged or claims special knowledge or skill in the type of sales transaction being conducted. Individuals who do not qualify as merchants in a transaction are known as casual sellers. You would be a casual seller if you sold your private automobile. A used car dealer selling an identical car would be a merchant. As a general rule, only the true owner of goods may legally transfer ownership of those goods. But, as with most general rules, there are exceptions. Persons may sell what they do not own if the owner has authorized them to do so. Salespeople in retail stores are so authorized. Auctioneers and sheriffs are also authorized when they sell, under court order, or when empowered by statute, stolen or repossessed goods. If an owner of goods is induced by fraud to sell the goods, the transfer of the title is voidable by the seller. Upon discovering the fraud, the victimized seller may cancel the contract and recover the goods unless an innocent third party already has given value and acquired rights in them. Documents can be legally created that convey title to goods in storage and/or transit. One example of these documents is a warehouse receipt, issued by the licensed warehouses for goods in a storage layer. Occasionally, a buyer will allow the merchant seller to temporarily retain possession of the goods after the sale. If during this period the merchant resells and delivers these goods to a good faith purchaser, the latter receives good title. Existing goods are physically in existence and owned by the seller. However, they do not need to be in a fully assembled and immediate deliverable condition. Identified goods are existing goods that have been designated specifically as the subject matter of a particular sales contract. The identification of such goods may be done by the buyer, the seller, both, or by mutually agreed upon third party. Unless goods are both existing and identified, they are future goods. Any contract for the sale of future goods is a contract to sell rather than a sale. Neither ownership nor risk of loss passes at the time of an agreement concerning future goods. In deciding when title transfers from seller to buyer, courts first examine the sales agreement to see if parties have specified clearly when they intended for the title to pass. If they express such intent, courts generally will uphold their agreement. If the contract requires a seller to deliver the goods to their destination, title passes when the goods are tendered at that specified destination. Tender of delivery means that the seller places the proper goods at the buyer's disposal and notifies the buyer so that delivery can be received. If the contract requires or authorizes the seller to ship the goods but does not obligate the seller to deliver them to the destination, title passes to the buyer at the time and place of shipment. when possession is transferred to the carrier. When customary or when the parties have agreed that the seller is to deliver a document of title, title passes when and where the document is delivered. If the seller is to tender the goods at the place of sale, title passes at the time and the place where the sales contract is made. The fact that a sale is made on credit does not affect the passing of title or risk of loss. A credit sale is simply a sale that by agreement of the parties calls for payment for the goods at a later date. A sale or return is a completed sale in which the buyer has an option of returning the goods. When goods are delivered to a merchant buyer in a sale or return, the ownership and risk of loss pass to the buyer upon delivery. Sometimes goods are delivered to the buyer in a sale on approval or on satisfaction. In such a case, ownership and risk of loss do not pass until the prospective buyer approves the goods. A person who sells a fraction interest in a single good or in a number of goods that are to remain together makes a sale of an undivided interest. Ownership and risk of loss pass to each buyer at the time of the sale of each undivided interest. An unfair method of competition is any method of doing business that is characterized by bad faith, deception, fraud, or a tendency to inhibit competition or monopolize. To protect consumers, the federal and state governments have enacted numerous laws prohibiting such practices. Competition drives inefficient firms out of business. Some individuals and companies enter into agreements to control or fix prices and thereby try to ensure their survival by eliminating competition. Such agreements are illegal and unenforceable. Violators are subject to criminal laws. False and misleading advertising intentionally deceives, makes untrue claims of quality or effectiveness, or fails to review critically important facts, claiming that a mouthwash prevents and cures colds and sore throats when it does not, is one example of such advertising. Some of the more common unfair pricing methods include intentionally misrepresenting that goods are being sold at a considerable discount and stating that the price charged for the goods is a wholesale price. Both of these unfair pricing schemes are illegal. Mislabeling a good to make it more marketable is an unfair method of competition prohibited by law. Even the shape or size of a container must not mislead the consumer into thinking the package contains more than it does.